So those people who I haven't met, Tim Nagel, my name is. I'm the Director of Workplace Relations Services here at VHIA. I'm also joined by my colleague, Tandis Ryan, who's one of our senior workplace relations consultants. And moving forward, we're managing the mental health portfolio. We have got a lot of slides to get through. The mental health agreement is one of the more complex agreements within our sector. Essentially, it's 4 or 5 agreements in one. So that means that there is a lot of changes to go through. So we've got about 203 slides to get through. We also have about 3 hours put away for this presentation. So I'm anticipating it may go a little bit over. But we'll get through it as quickly as we can, and then we'll try and leave some time for questions. In terms of the presentation itself, just so that people don't have to spend their time busily scribing, there is a copy of the presentation on our VHA groups page that people can download at any point, so they could use that instead of writing lots of notes. We will have an implementation guide and also a salary circular that'll be released in January, but probably I would be hoping to get that out next week. And the other thing that we'll do just to help with the implementation is that we'll publish a comparison document just to make it easier to see what has changed between this agreement and the previous agreement. And of course, we'll also do a podcast series where we look at some of the topics arising out of the changes in more depth. We should say that even though we do lots of things to support the implementation, it shouldn't be taken as a replacement for going through the agreement itself and making sure that people are across all the changes and how they impact upon their workplace. Just a little recap on the bargaining, because it has seemed like a lifetime since we commenced it. So we submitted the management look in March 2024, and that was approved by government in June 2024. So both those items occurred as anticipated. The bargaining proper commenced in July 2024, which is in accordance with the agreement, is 6 months prior to the commencement or to the nominal expiry date. There was approximately 152 separate union claims across the 2 agreements. So it's an extraordinary amount of claims, and we are seeing that in our bargaining processes where there are more and more union claims. It's actually more than 152, because that doesn't go into necessarily the sub-claims within individual claims and additional claims that were brought up sort of during the bargaining process. So the nominal expiry date was the 31st of December 2024. We normally have an objective of resolving the bargaining prior to that, but we were unable to do that. There was an offer made to the unions to settle it prior to that date, but that was not accepted. As people probably recall, both AMF and Haxley undertook protected industrial action at the commencement of 2025. The VHI lodged a Section 240 application with the Fair Work Commission on the 17th of July 2025, and that was really triggered by when it became apparent that we were going to need the assistance of the Commission to try and resolve some of the outstanding items. That occurred over approximately 4 conferences from memory, and there was a recommendation issued by the Fair Work Commission on the 26th of August 2025, which was accepted by the parties, and we reached settlement in September 2025, some 15 months after the commencement of the negotiations. The drafting took 6 weeks, which is an impressive feat and tribute to the collaboration between the parties to get that done as soon as we can. And the ballot occurred in December. It closed on the 23rd of December. There was one employer that we needed just to tweak those dates with, and that closed on the 31st of December with all ballots being successful. We have lodged. Ooh, I wonder whether we may just need everyone to be on mute. Just giving a bit of feedback. Hopefully that fixes that, which it does. Great. And we lodged an application for with the Fair Work Commission for approval of the agreement on the 5th of January. We have received an acknowledgement from the Commission just accepting that application, and we'll go through that process with them. Usually it takes their benchmarks are around 45 days for more complex agreements. And as I said before, there is no more complex agreement than the mental health agreement. So we anticipate using the majority of that 45 days, so which means that you probably won't get it approved until towards the back end of February, and it will come into effect 7 days after that date. So that's a recap on bargaining. So just in terms of the actual changes to the agreement, it's growing. So there was 17 employees under the previous agreement. With the new agreement, there'll be 20 employees. So that will be the addition of Northern Health, Western Health, and also Parkville Youth and Mental Health and Wellbeing Service. So we're up to 20. We will get to 21 with the next agreement, with forensic care also coming into the agreement. So that's exciting. In terms of how the sections are organised, it's the same as it currently is, with the exception that Section 4, which was previously the Health and Allied Services section, has just been renamed Support Services. But otherwise, the structure of the new agreement is the same as the previous one. So we'll work through the first section in Part A, the preliminary clauses. But just a little bit of tidying up, just in terms of making the agreement flow a little bit clearer. So people will probably recall the body of the agreement was in one particular order, but it didn't match the order of the schedule. So we've just fixed that up. Schedule 10 previously was additional staffing, but now it is bed-based staffing profiles. We'll get to that a little bit later. And finally, Schedule 11 was lived experience worker translation process, but that is completed, and it is now additional staffing. And in terms of the clauses covering the application of the agreement and sections 2 to 4, there are some amendments to those. So we have got the sort of the formal inclusion of like the RESON and the pre-qualified enrolled nurse, as well as the Indigenous nursing cadets, which are now mentioned as part of that Section 2. Section 3 has been expanded to recognise the Aboriginal mental health clinician. So once they're qualified, there is now a classification that covers them. Previous arrangements were that they were tied to social worker classifications, and it was all a little bit messy. So that's all been tidied up now. There's a new definition. There's a new classification for counsellor within the agreement. Exercise physiologists is being recognised, and pre-qualification health professional students have also been recognised as part of Section 3. And once again, just in terms of Section 4, the title has changed. It takes us to Clause 9, definitions. So there's been a few changes to the definitions section. Probably the first two there are the only substantive changes. So adoption now includes the placement of a child by permanent care order, and includes kinship care where it's comparable to adoption. And that's, obviously there can be variable circumstances that occur. So the where it sits is that it has to be the same as adoption when all the circumstances are taken into account. The other substantive change in the definition section is that a current foster child of the employee in the definition of immediate family has been included, and also the family of a de facto spouse has been included in the definition of immediate family as well. The rest are really sort of hygiene things. So bank employee is being defined, pool employee is being defined. They become important really around the change of ward allowance is probably where the work for those definitions are, but we'll come to that a little bit later. Uh, Other than that, there's really some sort of insignificant updates and changes. Nominal expiry date. The nominal expiry date in the new agreement is the 30th of December 2028. People will recall I said earlier that the previous nominal expiry date was the 31st of December 2024. It's gone back a day, so it's a 3-year, 364-day agreement, but that's probably not here or there. In terms of Clause 12, which is the implementation committees, that's just been updated to really make that distinction between the local WIC and the centralised MIC. And it also includes a list of priority items for the local WIC to consider as part of the implementation process. So there's a range of priority issues there that the unions themselves have allocated or identified as particular things they would like to focus on. But ultimately, the whole agreement needs to be implemented. So it's really just about priority items as opposed to any other purpose. In terms of Clause 16, which is the anti-discrimination clause, that's just been updated to reflect changes to the Fair Work Act and those protected attributes are identified in the Act, and they're the items there that have been updated. Clause 17 of the existing agreement and Clause 17 of the proposed agreement or the new agreement has been amended slightly. The purpose of the standing committee has been expanded to include job security, and also there's been a facilitated provision in the new clause to enable it to be a joint committee across agreements as opposed to having to be replicated for each agreement. So that is a change. And also gender equity activities at a local level has been included as a standing item at the local WIC meetings as well, just to get some engagement locally about how members are going about that work. And it's the same as the general nurses clause, so people will likely already be doing those things. It takes us to Part B, consultation, dispute resolution and discipline. So in terms of Clause 18, consultation, we have updated it, the same as the General Nurses Agreement, to include, for major change, to include temporary or urgent changes. It did anyway, but it's clarified within the new agreement. We do still have some resistance from the unions around including indicative timelines in the agreement, so they haven't been included, but our view is that the employer, in the absence of indicative timelines, the employer is able to set those timelines depending on the scope of the change. The other inclusion that will look familiar to people across both this agreement and also the General Nurses Agreement is the inclusion of a central building consultative committee. So this is in the same terms, different location, but the same terms. And that requires employers to establish a central building consultative committee in circumstances where they're proposing to undertake construction of a new or significantly changed work area, including new construction of a new facility. And it does a variety of things, but provides a framework for those discussions to occur centrally across unions as opposed to individually by agreement. And it's exactly the same as the General Nurses Agreement. Now, the Clause 19, which is consultation about changes to rosters or hours of work, has also been updated to align it more closely to the Fair Work Act provisions. So it does a couple of things. Firstly, amendments clarify how an employer consults with the employee where a change to the employee's regular roster or ordinary hours of work is proposed. So it actually gives people a more detailed process, including what information is to be provided to the employee, and also requires the employer to give prompt and genuine consideration to matters raised by the employee, including health and safety impacts. It really reflects what the Act says, and also reflects what the general nurses term requires. Clause 22, the dispute resolution procedure, has been updated to with amended words to reinforce the parties must attempt to resolve the dispute at the workplace in the first instance. We actually wanted it to go a little bit further than where we got to, but we have made some small steps in the right direction in terms of that. And really, this is about trying to utilise the dispute resolution procedure and the Fair Work Commission to resolve disputes between the parties without needing to go to federal court to do such things. The alternative dispute resolution procedure has also been revised. We didn't get much use of this in the last agreement. There was only one instance, but we did learn some things through that process. So as a result of that, we have revised the process to deal with classification disputes, including the material required to be provided. We've also clarified that a new panel is formed for each matter. It's not about the same panel for the whole length of the agreement, but it is formed each time an application is made. And there's just some clarification that a nominee of the panel does not receive any additional remuneration for their services. That just really goes to the issue about whether people outside of the sector can be nominated to participate in that panel, which they can at the minute, but they're not remunerated for that time. The managing conduct and performance has also been updated, and that's based on the general nurses clause. So a few changes there. Firstly, sexual harassment has been included as an example of serious misconduct, and that follows amendments to the Fair Work Act in the same terms. Secondly, that there's clarification that materials which form the basis of a concern include statements the employer has at the time, and they need to be provided before seeking a response. So that's obviously a point in time consideration. When you put the allegations to the employee, you may or may not have any statements at that point, but it clarifies what at that point needs to be provided. And finally, the new requirement regarding professional misconduct allegations to ensure that decisions around disciplinary action are informed by someone with a thorough understanding of the applicable professional standards of practice issued by the various professional registration bodies. So that's really about making sure that people making decisions about whether a particular behaviour or particular behaviour does or doesn't constitute professional misconduct, if they need to be aware of what those standards are. And it's virtually the same as the general nurses clause. The difference is that it's a bit broader than just the nurses. Modes of employment is clause 25, and really the amendments here are a result of changes to the Act. So we have made the necessary changes to align it with the changes to the Act in terms of the definition of casual employee and the considerations at appointment. So they have been included. We've also made compliance amendments to reflect the changes to the Fair Work Act provide an entitlement to paid family violence leave. So that has been amended. In addition, we've clarified that a fixed term contract can be terminated earlier than end date in some circumstances. We have reflected the legislative changes that restrict or significantly restrict the use of fixed term contracts. We have clarified that the effect of continuing to work beyond a fixed term period is that employment transfers to permanent employment, which is how the common law has treated that. And finally, a new term requiring rationale for a fixed term contract to be in a letter of appointment and termination. And that really goes back to the limitations on fixed term employment. So those changes are there. A casual conversion, there is another example of something that is increasingly being regulated through the Fair Work Act, and as such, we've needed to amend the agreement to reflect those changes, and also remove the changes that have already occurred, or the processes that are required by the legislation that have occurred and historically occurred. Now, employment checks is a new provision for the mental health agreement, and what this does is it requires, well, in the first instance, where an employee is required to, by law, to hold a check, it is the employee's responsibility to bear the cost of that. But where an employee requires the employee to hold a check that is not required by law, the employer bears the cost. So it just makes that differentiate between those two situations, and therefore where the employee will bear the cost and where the employer will bear the cost. It does define check to mean a valid police check, or certificate, a working with children check, and or an NDIS working screening check. And also, in case there is disputes about whether a check is required or not, there is the dispute resolution procedure that can be used to resolve that issue. It's exactly the same as the general nurses clause, so we anticipate that most of those teething issues have been worked through, and there's a similar but not the same provision in the health and allied agreement as well. So we do have some experience in the sector with this particular provision, so I doubt that it's going to be a significant implementation issue, but we'll wait and see. Employee retention, or at clause 27, it previously was employee retention and also transition and retirement provisions, and it was sort of a mixture contained within the same clause. What we've done in this agreement is we've just teased those out and separated them. So 27 has those measures taken in with a particular focus on employee retention, whilst 27A is particularly focused on the transition to retirement provisions, still focused on employee retention, but in specific circumstances. And that does take us to 27A, which is that transition to retirement provision. So in terms of the changes here, it includes the process to go through. It requires the employer not to unreasonably refuse requests, and it gives a range of arrangements that may be included in that transition to retirement arrangement. It's virtually exactly the same as the general nurses clause, so people will be familiar with that. Clause 28 is termination of employment. So this is a new common clause for the new agreement. So we had 4 clauses previously that were all very, very similar. So we've consolidated that into a single common clause. What that does is that it aligns various entitlements. So that meant that the support services notice increased to a base of 4 weeks. And it clarifies how payments in lieu of notice are to be calculated in terms of lost wages if people do want to pay them in lieu. There is previously there was a limit. There wasn't a limit in how much could be deducted from an employee's pay if they didn't serve their notice, but that's inconsistent with the modern award and potentially the Act. So that has been reduced to align with the Act. And what that means for people is that if people don't provide the notice, then there is an opportunity for employers to reduce uh, reduce by 1 week the payment. Uh, in addition to that, just to align the entitlements, there was an expansion of an entitlement to take a day off without loss of pay to seek other employment where the employer has provided notice and termination to employees. So that was a current entitlement, but to a smaller band, and it's been expanded to all employees covered by the agreement. Return of property, I think originally was 28, but now that's a sub clause of clause 28. People are looking for it. I'm wondering whether just anyone's got any questions about any of those clauses, any burning questions. We might just pause for a sec just to see if anyone wants to ask any questions. Okay, we will continue. Payment of wages, allowances, employee records and related matters is at clause 29. This was one of those clauses that where there are multiple provisions throughout the agreement that sort of largely dealt with exactly the same subject matter. So they have been consolidated into one clause. There wasn't much variance in what they were saying. They were virtually saying all the same thing, but the Act deals with it as it is. So we base the provision on the general nurses course, so people will be familiar with that. People should just remember that there are provisions in the agreement around overpayments or underpayments and penalty payments, so they are unchanged. But the core of the work, compliance work, is done by clause 29. Clause 30, which is compensation make-up pay. People will probably be thinking, what is compensation make-up pay? But it's the new era of the accident make-up pay. And what the changes here are is that there's been an amendment to increase the rate to which wages are made up to. So instead of ordinary time earnings, which they historically have been, they've gone to scheme determined pre-injury average weekly earnings. And what that really means is that shift penalties, etc., are now considered as part of the determination about whether make-up pay is applicable. So people will end up being able to access make-up pay for that. It's exactly the same approach as been taken in the general nurses clause. So people will have an approach to that already. Salary packaging, new obligation where an overpayment occurs due to employer error. The employer will refund the overpayment to the employee and recover from the provider instead of requiring the employee to do that. And there are some saving provisions just in case, just to prevent the employee from getting multiple refunds. So there's a process to be followed there. But it's the same as the general nurses clause. Superannuation has been updated. There's been some changes in this space over the last few years. So they reflect those changes, including the establishment of stable funds and the role stable funds have within Victoria. Um, There is a new entitlement to superannuation being paid on particular types of leave. So as you can see there, during parental leave, which was done previously, superannuation was also to be paid on defence leave, jury service, and no safe job leave, whether that's paid or not paid. And from the 1st of July 2027, superannuation will also extend to workers' compensation payments as well, with the objective of ensuring that there's not a gender imbalance between lifetime superannuation savings for our workforce. There has been an amendment just clarifying the calculations of the superannuation for people who are on parental leave and the timing of payments and pay slips, because that is something that emerged as a challenge after the previous policy decision from the government. And again, those provisions are the same as the nurses, so people will be familiar with how to implement them. Travelling and reimbursement, this is a new sub-clause within clause 35. And this applies where the employee is required by their employer to live away from home. So not a common situation, but it has occurred from time to time across the sector. And it just provides a framework for how they're compensated in those circumstances. And that involves them either being provided with reasonable accommodation, food and drinks at the expense of the employer, or being paid an allowance for such, which is based on the ATO rates. But again, it's the same as the general nurses clause, so people will be familiar with that. The right to disconnect. So this is a little bit different to the general nurses agreement. This is a standalone clause in the common section that really seeks to replicate the changes to the Act. There is some additional provisions included in Section 2 that do replicate the general nurses agreements and are more confined to particular circumstances, but Clause 36 is designed to replicate what the Fair Work has to say about rights to disconnect. Personal leave. So we have managed to consolidate personal leave away from the 4 individual clauses throughout the agreement to one common clause. So that's contained at 38A. Probably the impact of that was the expansion of the additional 30 hours and 24 minutes of slash personal slash carers leave. I think it's actually compassionate leave as well, but it doesn't really cater for that. Expanded to all employees where paid personal leave entitlements is exhausted. So previously that was limited to, from memory, sections 2 and 3, but now that it's been expanded to all. Actually, it may not have been 3. But anyway, the new agreement, it's expanded to all employees as part of the common clause. The other changes to personal leave are the loss of pregnancy added as an example of a personal illness or injury affecting an employee's immediate family or household, which therefore allows people to take carers leave in those circumstances. The ability to use 5 days per year to attend a registered health practitioner appointment or diagnostic appointment, just trying to cater for those people where they're not unfit for work, but there are medical reasons why they would need to attend those things. The ability to use up to 5 single days absences without evidence of personal illness or injury. We have standardised the notice and evidence requirements across the various sections of the agreement to align with the NES. So that gives us a common standard to go to. And the extension of portability of personal leave to a council in Victoria or public health service in another state or territory, which was an outcome for the general nurses agreement, which has come into this agreement as well. Same as the general nurses clause, other than that first point on the previous slide, they don't have that additional historical leave where personal leave or carers leave is exhausted. 38D B has been introduced. Oh, Gary, you had a question?
Yeah, thanks, Tim. Just with the personal leave entitlements, so forever it's been 3 single days and then stat decks. So the stat decks have gone now, is that right?
Yes. So the common, so you've got the amount of days without the,
Without any evidence, yeah.
yep, and then all the remainder is the NES standard, which is evidence that satisfy a reasonable person.
Okay, so the reference to stat deck for 3 occasions for up to 3 consecutive days is gone.
Yeah, correct.
Yeah, cheers.
Clause 38B is personal leave pool. So we know that some members were doing this, which is great, but there was just a compliance issue with the agreement. So we're putting in a facilitated clause to enable people to do that should they wish. People should just keep in mind that the personal leave pool is still limited by the NES entitlement. So whilst you can use anything above that, you really shouldn't use anything below the NES because that might get us in trouble still. But in terms of the agreement, there's some compliance for that above NES requirements. Caring responsibilities for casual employees. So again, this is one of those ones where we've been able to consolidate into a single clause. And for this, there was largely all saying the same thing. And it provides the NES entitlement so that casual employees may take unpaid carers leave in certain circumstances. Annual leave is another clause that we managed to consolidate into a common clause, which is a positive. So we removed the individual provisions in each of the sections, and what that does is it creates a common condition across the agreement. So all full-time employees receive 5 weeks of annual leave as the base entitlement, which is an increase for some of the sections. The other change is that annual leave loading is paid on all 5 weeks. There was some challenges with it being limited to 4 weeks for those sections that had a 5-week entitlement, but that should be resolved. We had the same savings provisions for Section 2 in terms of how the additional week accrues. So we have a simplified approach, but we have put some savings provisions in to protect people who are doing additional amounts of things under the previous regime. And just so people understand what that is about, it's the previous entitlement was to accrue the additional week if they were working weekends throughout the year, but throughout was not defined, so people were doing different things with that. But we've preserved those arrangements under the existing agreement if they're more favourable. The insertion of a process to manage annual leave requests for high demand holiday periods has been included, as well as the standardisation of the excess annual leave provisions. So these will be familiar with people who are familiar with the General Nurses Agreement because they really replicate those provisions. Reproductive health leave is a new leave type that has been introduced into the mental health agreement for the first time within our sector. It has appeared elsewhere within the public sector, but this is the first time in health. So the entitlement, as you can see there, is an employee may take up to 5 days, and it's prorated for part-time employees per year of service, where the employees are able to work as a result of experienced symptoms associated with endometriosis or polycystic ovarian syndrome. It requires medical care for treatment of or associated with those conditions, or is undertaking a medical procedure associated with assisted reproduction. So they're the circumstances that it would be applicable in. You'll see that those that are familiar with the bargaining process will know that the initial claim was a lot longer list, but this is what was included in the final settlement. In terms of accessing that, it is contingent upon the employee having a balance of personal leave of 15 days or fewer. So they only become eligible for this additional leave if their personal leave is at a certain level of 15 days or less. And in terms of evidence, it's evidence that will satisfy a reasonable person. So again, the same as the personal leave evidence test from the Act. The other leave type that's new for the mental health agreement and also new for health sector is the alcohol and drugs rehabilitation leave. And what this provides is an employee, not a casual, so a permanent employee may be granted up to a maximum of 30 days of paid rehabilitation leave over the life of this agreement. So it's not each year, it's over the life to attend an alcohol and other drug treatment program. and they may include residential or home-based settings. In terms of evidence requirements, employee must provide the employer with evidence of enrolment and the program's attendance requirements as well prior to the commencement of the program, and the employer may also require evidence of ongoing attendance at the program, just to ensure that that leave type is being used for the purpose it was intended. Special disaster leave has been amended for the agreement. Primarily, the change has been to go from 3 days per occasion from 3 days per year. So there has been an increase and reflects the fact that special disasters may occur multiple times a year. It includes a reasonable person evidence test. It also just amends or addresses a bit of a nuance in the previous clause that saw circumstance where an employee's own life and safety is threatened and not qualifying them for the leave, but if their families is that they did qualify. So that's been addressed. But for those familiar with the General Nurses Agreement, again, they will be familiar with the same approach. Gender affirmation leave, a new title, previously known as gender transition leave. The only other change to that clause is just clarification that the employer may agree to go beyond the clause, beyond the 52 continuous weeks. That's what the initial entitlement is catered for by mutual agreement, basically. Cultural and ceremonial leave, which is an existing clause, has just been amended. So there's a couple of different components to it. So the new entitlement of 1 day of paid leave per calendar year for NAIDOC week, or similar activities and events not otherwise covered by ceremonial leave. So similar activities to NAIDOC week, that is. Ceremonial leave, insertion of additional 3 days of paid leave each year for ceremonial purposes, and finally up to 10 days paid leave to enable people to participate in First Peoples Assembly of Victoria. So that clause is also based on the General Nurses Clause, but that in that first dot point, all similar activities and events not otherwise covered by ceremonial leave is different to the General Nurses Agreement. That is a particular nuance from the Mental Health Agreement. Compassionate leave, it's just been amended to clarify the notice and evidence requirements, which from memory is aligned with the Act. The family and domestic violence leave, so it has been changed in terms of including the reference to domestic. And there's been clarification of another thing that the payment is if hours is worked. So as opposed to base rate, it's encompassing entitlements that occur as part of shift penalties and rights for business. It extends the paid entitlement to casual employees as per the Act. Clarifies the meaning of year, ensures minimum entitlements for part-timers of 10 days per anniversary year. So that's just making sure that it complies with the Act, because you can't just simply pro-rata the entitlement, because we will run foul of the MES if we do that. So there's some provisions just to enable that minimum entitlement. Long service leave, my favourite clause. So a couple of changes here. Recognition of service with a public health service in another state or territory and a local council in Victoria. So that is a new entitlement from a point in time, being the 20th of May 2025. So it doesn't go, there's no retrospectivity. I'll just getting some feedback that I'll just repeat that. Just let me know if it's not clearer. So long service leave, first change there is recognition of service with a public health service in another state or territory and or local council in Victoria. And it doesn't operate retrospectively. So it's where they're coming to Victoria from the 20th of May 2025. Clarification of calculating payment for casuals and part-time hours. Okay, great. Thanks, Gary. Clarification of calculating casual payments and also part-time payments where that part-time employee's hours fluctuate. The clause enables the taking of single days of long service leave. There are some other minor changes. HACSU identified that there is a list of employees in which category of long service leave they fall into, and that just wasn't comprehensive. So it's been amended to do that. And also, there were some unpaid parental leave provisions in the previous agreement, and how they were dealt with that were transitional, that had been incorporated into the clause proper. Foster and kinship care. So it applies to employees who provide short-term foster or kinship care as primary caregivers to a child who can't live with parents as a result of an eligible child protection intervention. So it's quite limited circumstances. And it's to be taken at the time of the placement of the child which the employee commences. So it's 2 days paid leave on up to 5 occasions per calendar year. And it's a reasonable person's test in terms of the evidence, but it is the same as the general nurses clause, so people will be familiar with that. Foster and kinship care. So we've got foster caring, which is a temporary care of a child up to 18 years of age on a short-term basis by an employer who is an accredited foster carer. Kinship care, which is temporary care provided by an employee who is a relative or a member of the child's social network when the child cannot live with their parents. These are just the definitions used. And Aboriginal kinship care, which has been defined as a temporary care provided by an employee who is a relative or friend of an Aboriginal child who cannot live with their parents. That's the second subclause of that foster and kinship care. So it just spells out which the individual circumstances are. Clause 49, prenatal leave. It's just been extended to cover assisted reproduction appointments. It's the same as the general nurses. Takes us to parental leave. So here we have some changes that really have been made to reflect the national employment standards. Those people who are familiar with the range of changes to the Act over the past little while will be aware that parental leave seem to be where most changes have occurred. So there's had to be a host of changes to our parental leave clauses to make sure they maintain compliance. From the commencement, in addition to that, from the commencement of the agreement, there's a removal requirement to have 6 months permanent employment prior to accessing parental leave entitlements for permanent employees. The clarification of a week of pay for parental leave is a change as well. Prohibiting employers from unreasonably refusing employees on parental leave who want to work keeping in touch days is a change. And finally, the ability to use annual leave and long service leave in conjunction with parental leave is a change. But all those changes are in exactly the same terms as the general nurses clause. So people will be familiar. Fitness for work has been included in the agreement. So it's in the majority of the other health agreements, but it wasn't included in the last agreement, but has been included in this agreement. So this describes the process to be followed in the event the employee's manager forms a reasonable belief that an employee may be unfit to perform their duties. So it's really about circumstances where the manager thinks the employee is unfit, but the employee doesn't have insight into that. Um, when we first created this clause some time ago, it was really around drug use and those sort of things where people just don't necessarily have that insight, but others around can see the risks. So that means that it sort of doesn't apply to certain circumstances like periods where the person's on leave, personal leave, or active work cover claims. This is really about where where the manager sees it, but the employee doesn't necessarily have that insight. And it's the same approach as the general nurses clause and others, I think, from memory. Climate change mitigation and sustainability is a new clause for the mental health agreement, but not a new clause for the sector. What it does is it introduces sustainability representatives, up to two per ward or unit, with at least one of those being a nurse. And what this involves is time release to participate in such activities to not be unreasonably refused. So it's within work time activities there where someone can be released to focus on this area. It also calls out that education concerning climate may be directly relevant to someone's professional development leave applications as well. And also, there's a facilitative clause between the employer and unions regarding reports required by the Climate Change Act of 2017. So there's some mandatory reports there. So it's about providing some opportunity for local discussion about that. Now, clause 55, sorry, recruitment to a vacant position. There's no substantive change. It's an unchanged obligation, but what has changed is the coverage. So it has been expanded from acute inpatient units to all bed-based services. And that's because of the bed-based staffing profile. So as we'll see later when we talk about the bed-based staffing profiles, part of the obligation is for employers to try and maintain those staffing profiles through quick recruitment and all those sort of things. So it's connected with that. And what this clause really requires people is to advertise as soon as possible for replacements. Community mental health discipline mix. There is just an obligation to provide reports every 6 months just around the discipline mix. That's an existing obligation, but the reporting obligations have just been strengthened a little bit because yeah. Donna?
Hi, Tim. Thanks. On that particular one, I note that it says that the agreed template will be provided to us via the MIC, and given this is required immediately following 30th of March, and it's highly likely that we'll have a agreement operating in that time, when would employers be anticipating getting the agreed template from the MIC?
Yeah, so it sounds like a what do we call it before, a priority item for the MIC to do that, I think. So I've wrote a note down there. We can do that ASAP. My memory is that there was a template used under the existing agreement, which might be able to provide us a starting point. But to your point, Donna, you will need that sooner rather than later.
Appreciate it. Thank you.
Clause 57A, which is new provision. So this is really talking about the establishment of community health team staffing profiles. So in the first 6 months from the operation of the agreement, work will be undertaken by the parties to map the staffing levels for community mental health teams and to record as a minimum staffing level for those services. Part of the challenge for this was the interaction between numbers of staff and discipline mix. So it's not about discipline mix, it's just about the numbers of staff. So these minimal levels and change arrangements were recorded in an MOU between the department, VHA on behalf of employees and both unions. Backfill is unchanged. There's no requirement to change backfill arrangements. They remain unchanged, and there's still going to be capacity to change those through the consultation process if required. CWMS. So existing CWMS will be replaced with the generic electronic system as soon as practical, but no later than the end of 2027. So that will be a funded project by the department to do that in conjunction with health services. So that is exciting. I know that through the bargaining process, those health services had electronic systems were at a significant advantage. So that's great. There is some provisions that have been included around non-compliance with the 60-40 split. So from the commencement of the agreement where the employee's workload remains non-compliant within 2 months after the completion of the monthly reporting period, the employer will take the following steps. The employee will be rostered for a clear day free from direct clinical care during the next reporting period, and also the employee will not be allocated any additional cases until the 60-40 threshold is met. So that's in there, and that won't apply in certain circumstances. I'll just go back to C. So C changes once the electronic process comes in for everyone. So because it's manual at the moment, there's people are given a longer time to do the necessary reporting and analysis and make the change. But once it's electronic, then the view would be that it would be a lot quicker turnaround than that. So those circumstances where it wouldn't apply is where the employee does not complete the tool. So if they're not facilitating the process, then the employee is not penalised. Or alternatively, the employee has been on periods of absence that distort the reporting results. And finally, where the MIC through consensus provide an exemption, and that may be in particular circumstances where health services have particular workloads that are unavoidable. That's clause 60. Clause 61, which is the CTWMS. So a bit of work was done around the interaction with leave. The 61.2 has just been amended to remove works. I just have highlighted will be rostered. So an employee out of a crisis team will be rostered the following time free from direct clinical care. So that just really goes to personal leave, and personal leave on days that cover those days don't need to be re-rostered. And what we've done is we've set up a sort of a process to cater for periods of planned leave during the next roster period. So if someone's working 0.9 to 1 EFT, then the entitlement for time free from direct clinical care is reduced depending on how much paid planned leave they have during that roster period. So if it's greater than 3 weeks, then they have no days rostered. If they've got greater than 1 week but not greater than 3 weeks, then they have 1 day. If they have less than 1 week, then they have no days. So it's trying to make it all within the roster period, depending upon how much planned leave they are rostered to take. And the same thing applies for 0.4 to 0.8, but less complicated. So a week, just in terms of definitions, so a week of time is defined as half their fortnightly contracted hours. And some people may still take planned leave in an unplanned fashion during the roster period. So that will be consolidated during the next roster period. But as we know, the majority of leave is planned in advance. So this is one of those ones where we'll do a podcast quite early on, just as part of the implementation, and clause 60 as well. Union Matters, Clause 63, there were some significant changes to the Act in terms of union matters and delegates' rights. I think they come out of the construction industry that weren't necessarily transferable to health, but we have made some changes for compliance to facilitate those changes. And really that comes down to recognition of delegates' rights and also the facilities that delegates will have access to. But the changes to the mental health agreement is largely based on the general nurses clause, so that won't be new to most people. Flexible working arrangements, clause 65. So there's been some amendments here to accommodate the changes to the NES. Pregnancy is a specified circumstance with respect to eligibility has been included. A list of the reasonable business grounds have been included. A prescription of information that must be included in a written response where the employee refuses the request has been included, and also the obligation to generally try and reach agreement. So it may be that what's specifically being asked for can't be accommodated, but something else can be that may be acceptable for both the employer and the employee. So it's really about facilitating that process. There has been included just a cautionary note around the interaction between a flexible working arrangement and inherent requirements discussions. So they're separate things, and that's just pointed out within the clause. The third point there, which is different to the general nurses agreement, the rest is the same. A removal of the qualifying period where circumstances have unexpectedly changed. So this is about where an employee starts and for one reason or another, their circumstances have changed and it doesn't preclude them from requesting a flexible working arrangement. But what we don't want is someone knowing going into a role that they're going to have to make a flexible working arrangement. That's not what that's about. Reasonable adjustments for employees with a disability. So there's just been some compliance amendments there, and it's the same as the general nurses agreement. In terms of OH&S, there has been some. Oh, I think someone might need to pop on mute. So what we've done is the previous OH&S clause, as people will know, was quite unwieldy. So if someone was looking for a particular topic within the OH&S clause, and they virtually had not much hope of knowing where it was, let alone finding it in a hurry. So we've just split them out to individual clauses so that people can use the index to identify the location a little bit easier. So that's what we've done initially. In terms of the individual components, clause 69A, which is how we've done it, 69A, B, C, etc. So 69A, which is the OH&S working group, we've just made some amendments to include a psychological injury as an area of discussion for the industry OH&S working group. It should be great, very topical at the moment. The OH&S risk management clause has been amended just with a new provision that requires employees to brief all staff as the need arises about individuals who present with behaviours that pertain to potential risk of OVA, and I'm sure employers do this already, but just making sure that anyone coming into the unit is aware of any risks that may place them in danger. There's also a provision, just a facilitated provision around manual handling review in conjunction with the HSRs, and that's in the same terms as the general nurse, but provides a process for how that will occur. Incident reporting, investigation, prevention. There's just clarification that employees may have a representative in attendance during investigation processes. It's arguably not required, but has been inserted as a clarification. And also that participation in psychological support is voluntary and confidential. Again, not necessarily that something needs to be amended, more a clarification than anything. HSRs, just the maintenance of a list of DWGs, as well as the names of elected HSRs and vacant positions. Also a process for supplying them to the various unions. So that is the same as the general nurses term. Hazardous weather conditions is something different. So we haven't seen this in within health. So this is a new one for us. And really, the key is there at sea. So where weather conditions create a potential risk to an individual's health and safety, this will be reported and actions will be taken to assess the risk and implement the hierarchy of controls to reduce the risk as far as reasonably practicable. And those hierarchy of controls may include particular actions by the employer, but it's exactly the same process as any hazard that's identified within the workplace. But one of the unions had a particular concern about hazardous weather being a identified hazard within the workplace. So today, including the process that people would follow if that occurs. Prevention and gendered violence, including sexual harassment. So this is a requirement for employers to maintain policies regarding work-related gendered violence, including sexual harassment. There's no doubt that people have these already, and they definitely do, given that it's a requirement of the general nurses agreements. But there is a process to provide policy to the WIC for the purpose of discussion and feedback. That takes us to section 2. Was there anything from section 1 more broadly that anyone had a burning question that they wanted to ask? Your chance to have some water. Okay, let's press on. In terms of clause 70, we did just so I should say that we did intend on trying to preserve the current numbering, not to change it, because I know that people become very familiar with the particular clauses, particularly when they've been there for a very long time. But unfortunately, it's just started to look a bit silly because we had lots of clauses that were empty. So the lawyers that were supporting the process have consolidated, which means that the clauses have changed, unfortunately. So it will take us a little bit longer to get a little while to adjust, but I'm sure we will be able to. So in terms of clause 70, definitions specific to section 2, the amendments to year of experience regarding concurrent service have been aligned with the general nurses. And this is really saying that experience in another health service or working as a nurse elsewhere counts towards progression through the structure. It's the same as the general nurses. Letter of employment arrangements. Requirement to provide employees with an updated letter of appointment where the employment is varied within 28 days of the variation. This is really just about trying to create some paper trails to in case of dispute. And where a kiosk, it doesn't have to be an actual physical copy where people use kiosk or similar facilities to generate those. But the record of that change is important, and that provision is the same as the general nurses provision. In terms of our mental health officers, colleagues, they receive a lump sum payment as part of the settlement. So they'll get it, that'll be due the first full pay period commencing after the agreement commences, and the total payment is $5,304, and it's split into two equal payments of $2,652. So that's for a full-time employee. It's part-time employees. And it's also payable to casual employees. I'm not sure how many casual employees we'll have in this particular cohort of employees, but it's based on average hours over the previous 12 months, calculated at the time the agreement commences. So it also applies to our casual colleagues. We've had a big win in the Clause 79 space, so we're restricting the payment of meal allowance in cash to where it's practicable. Under the previous agreement, the employees had the entitlement to be paid cash for meal allowances, but that has been limited somewhat. Our qualification allowance, there has been some amendments to the qualification allowance. Again, in the same terms as the general nurses provision, it's really designed around reducing disputation around the process for recognising qualifications or rejecting qualifications. So the new requirement is for employers to maintain a system of work that requests information regarding qualifications by the employee at commencement of employment. And it also has a requirement for employers to substantively respond to applications for qualification allowance in writing within 28 days of receiving an application. There is also a process for existing employees that are doing the qualification as part of the workplace. So there's also those, and again, they replicate the general nurses provisions. There is with the redeployment. Donnie, you had a question?
Thank you, Tim. Just clarifying, I know quite a few of the new entitlements are retrospective to a certain date, but it doesn't appear this is. Is that correct, that it's from commencement of the agreement?
Yeah, someone raised this with me yesterday. So what I was going to do, and I haven't done that yesterday, is just go back and put into the implementation guide around the dates,
Thank you.
which I think will be helpful for people, because I think that's because there is some retrospectivity of the agreement to when the settlement was reached. But the next question becomes, well, which ones? So I thought, I thought the implementation guide would be a useful addition to that.
Thanks.
So with the introduction of a redeployment allowance or change of ward allowance, the interaction with the qualification allowance becomes a question. So that is resolved by it being payable if people are redeployed. And I think it's payable across the board in terms of if they're working in alternative areas as well. There's an increase in the high qualification allowance by 50% from towards the end of the agreement, but that's a significant increase to the qualification allowance. Hopefully that encourages a lot of our colleagues to access those high qualification allowances or to undertake those. Yeah, and that last dot point, or the second last dot point, is what I was alluding to before, just the clarification as to how qualification allowance applies where multiple roles are held. And so it is the highest allowance applies to all shifts. And those changes are the same as the general nurses agreement. I think maybe the date might be different. Otherwise, it's the same process. Saturday and Sunday work, just ordinary hours of work defined, and clarification about the casual loading for weekend workers, which is a compounded rate, is included. Our shift allowances is there's a big change there for shift allowances, in particular a night duty allowance. So people will recall we largely had a flat rate previously, but that's been broken up to really reflect the modern award approach, and that is that the shift allowance varies depending upon which day it is. So, for instance, the to Monday to Thursday, it's night shift is a particular rate, and then there's a higher rate for Friday and Saturday, and then there's an even higher rate for the Sunday, which incorporates the previous trial rate as well. So really, it's based upon trying to increase attraction for some of those harder to fill shifts. Just interrelated with that is a desire to try and improve or increase permanent employee incentivize that. So as a result, the casual night shift hasn't increased by those amounts and remains the flatter rate. So there is an incentive for people to transfer to permanent work to access, particularly night shift workers, to access those higher amounts. They're based on those, but the actual rates are in Schedule 2. A change of ward allowance has been included in the mental health agreement. So the actual entitlement is that a change of ward allowance applies where at the initiative of the employee performs their roster shift at a ward, unit or department that is not their base ward, unless an exception applies. We'll talk about those exceptions in a minute, but the base ward is defined to mean the ward or unit to which the employee was rostered to work in accordance with their rostered provision. So if you're rostered in one unit and you work in another unit, you perform your rostered shift in another unit, then you qualify for the change of ward allowance. That performs their rostered shift is important because it's not people who just go for a portion of the shift don't qualify. It's really that they've got to do their rostered shift or the equivalent of their rostered shift. And what that means is that, you might not be sent at the first minute, you might be sent, 15 minutes into the shift or at the end of handover or whatever it is, but it's effectively for the rostered shift. And you would qualify for the change of ward allowance unless one of the other exceptions apply. The provision also ensures that rosters are issued on a per ward or unit basis. It is the same as the nurses without subclause 6, which is about clinical sections within a unit. And our experience has been that subclause 6 created a significant amount of implementation issues, but the rest of the clause was rather straightforward. So that should be hopefully our experience within mental health. In terms of what those exceptions look like, I've just highlighted the key ones, and they are casual bank employees and pool employees. So again, important just to go back to those definitions that we pointed out earlier on in the session, just for a meaning of those, because they might not be called pool employee, but they may meet the definition of pool employee. Also, someone who is not ordinary working award is covered by that exception at C. And the other one that's important is where a nurse is required to follow their patient to other units or wards. So probably more the case in the general area, but I'm sure that has some application in mental health as well. In terms of hours of work, insertion of a 12-hour shift arrangement provision, which is the same as the general nurses agreement, and stronger provisions to enable employees to schedule their accrued days off on a date they request, which has also been accommodated. Clause 89, overtime. Inclusion of a definition of reasonable overtime that comes from the Act. Clarification of double shifts as overtime. So it's not all overtime, but some of it is overtime because it's longer than the shift length. Extension of transport being provided to the employee by the employer following overtime, including the return journey when the vehicle remains at the work. And clarification that 10-minute breaks during overtime are paid breaks as well. So they're the same arrangements as the general agreement. A permanent night duty has been included in the agreement. And what this is really trying to do is establish a process for to facilitate those people who want to do night shift doing night shift, and those who don't want to do night shift doing as little night shift as possible. It's not always going to be the case, but that's the objective of that process. And what it does is it establishes a process to work through that. It's the same as the general nurses agreement, which generally the experience was that it worked reasonably well in terms of working through the process. It's a little bit more specific in the mental health agreement about how that might be undone. So it uses the consultation about changes to rosters or hours of work if people want to do permanent night shift, but there's no permanent night shift positions available, then there's an opportunity to work through that. So, but I think it's a relatively straightforward process and clear. The other thing I should just mention is that it also provides provisions where people are required to come off nights for education, that they still are provided with the financial benefits of working those night shift shifts. So it just creates a incentive for one, employers to provide that on night shift where they can, and B, for people not to resist coming off if it's absolutely necessary for education and other purposes. At the same time as that, we have 90B as well, which is really about designing some rostering principles at a local level about how, for those non-permanent employees, non-permanent night shift employees, how night shift is arranged so that health services requirements are still met, but there is some level of input from the workforce into how they occur. And this is really off the back of the work that was done, I'm going to say at St. Vincent's, but I'm not 100% on that, in their ICU about what things employers could put in place to help employees sort of manage those requirements of the roles. There is an additional element in there just about a minimum of 47 hours break provided after permanent for non-permanent night shift employees. And that's really just an OH&S thing based on WorkSafe recommendations around transition from night shift to day shift. Uh, 90C is a new provision. And really what this seeks to do is to provide a pathway for amending or a couple of provisions in the agreement. So the 4 clear days allowance. So there is a opportunity for people to do something else. This provides the process for people to be able to do that. The same as implementing a 12-hour shift agreement. This provides a process to do that. And finally, amending an existing staffing profile as well. And that's not including where there's a change to bed numbers. This is where there's no change to bed numbers. There is a process in the agreement to go through that enables people to change those profiles. On-call recall. This is the one I think I mistakenly put the night shift as a reflection of the Act as opposed to this clause, but I'll correct that. So this provides different on-call recall rates for different days of the week. So, for instance, a weekday is less than a Saturday, which is less than a Sunday, or a weekday public holiday, which is less than a weekend public holiday. So different rates. And that is from the commencement of the agreement, retrospective application to the 20th of May 2025. There is a provision that deals with where an on-call period, so the 12 hours, goes across times with different rates. So, for instance, if you are working, if you're on call for 12 hours starting from Friday at, 5 o'clock and it finishes at 5 o'clock on the Sunday, then because the Sunday rate's higher, then the Sunday rate applies to those 12 hours, that 12-hour period. So it just helps identify what the rate is for that 12-hour period. It also clarifies if an employee is recalled and then that recall is cancelled, will receive the minimum recall payment of 3 hours. So once you're called and told to come in, then if I cancel you, then you get the disruptions occurred and you receive the 3-hour minimum payment. Also, there's just some clarification on how to calculate recall in the event of multiple recalls. So again, it's one of those situations that people were doing different things, so it's standardised it within the agreement. So there will be one approach, and those rates are based on those calculations, but the exact rates are in Schedule 2. A cat on call, again, is a little bit tricky, a cat on call, because it's sort of the non-cat plus an hour, which doesn't necessarily interact with that methodology as well. But there is a process that we've got to calculate those rates in relation to a relativity on a relativity basis with the existing differential. So that's been included, and then the same provisions apply as those other non-cat on-call rates, and those rates are in Schedule 2. But you'll see it really does just maintain the differential between the two. 10-hour break between overtime and recall. So there's just a shift in the language so that it's triggered now if it requires a 10-hour break after any shift that involves overtime, regardless of whether the overtime was done immediately prior to the shift or after the shift, because there was just so that clarifies. So it makes it so that people don't have to amend shift times and all that sort of business that people are going to qualify for anyway. 4 clear days, which is one of those provisions I mentioned before. So from the commencement of the agreement, the insertion of an amended term that provides an allowance of 3.167 hours of ordinary pay when an employee does not receive 4 clear days from duty each fortnight, and that's capped at an additional week. So that's in place. But again, people may agree on an alternative, and there's capacity to do that. So that should simplify that process for amendments. And that's the same as the general nurses provision. So there's the introduction of a process to clarify which employees are not required to have a roster published, and that's to occur within 6 months of the commencement of the agreement. There is an introduction of a financial penalty if roster is not posted as required. So that's equivalent to 14 to 7 days change. There's a reintroduction of the requirement for meal breaks to be included in the roster, but what we have done is included an alternative mechanism being available should recording of the meal break on the roster not be possible, which we strongly suspect it's not. But we know it's not, so that's why that mechanism is there. Okay.
Yeah, Tim, with the financial penalty related to the roster not being posted, there'll be details of what that penalty is, who it applies to, how it's applied, how long. I think I said something about a change of shift allowance or something being paid if it's not published in time, but is that per shift, per roster?
Per shift, yeah. It's the equivalent of a change of roster allowance.
So for
per shift.
every day or every day that the roster is not in line, everyone on that roster gets paid the share.
Correct.
Yeah, okay.
So currently there's a requirement to publish it, a certain time, but there's no penalty. So what the general nurses agreement did is it introduced a penalty to ensure it happened because it wasn't happening all the time. And how it operates is that it gets paid for each day that it's late, essentially. So, if it's released one day late, then the first day of that roster, people are going to get the penalty for that first day.
So
They're
anyone
they're
who's
rostered.
rostered on that day.
That's
Yeah.
right.
Okay. All right. Thanks,
Yeah.
Tim.
So there's a requirement to roster 2 consecutive days off a week for employees working above 0.8 EFT. Whenever practical in ADO, will on a date requested by the employee. That seems to come up a lot in this presentation. Enabling of a fixed roster request in circumstances where the employer is proposing to alter or has recently altered the employee's regular and systematic pattern of work. That's really just adjunct to the current ability to fix a roster. Gary?
Sorry, Tim.
You're
With the 2 consecutive days off, there must be, unless an otherwise requested type statement. Is there? We're not.
Yeah, there is,
Oh,
Gary.
okay.
Yeah,
All right. Yeah.
sorry.
Okay.
No, there is.
Thanks.
We know that certainly some employees will face circumstances where split days off is exactly what they want. Clarification of the operation of the change of roster allowance, just to make that clear, an insertion of process for employees to be requested to work a public holiday just to reflect compliance with the Act. So that's about offering and then people refusing and then considering whether it's a reasonable request. So that process has just been baked into the agreement. A supplementary roster, just clarification that if an additional shift is worked by a part-time employee other than under the supplementary roster, it attracts the change of roster allowance. That's how it operates, but that's just been included as clarity. Right to disconnect. So the requirement for an employee to review its arrangements for contacting employees out of hours to determine their availability, just to ensure that systems for contact is as efficient as possible and therefore avoids unnecessary contacts. There was some examples, and I'm not sure it's a big an issue in mental health as it is in the general area, but in the general area, there was a number of examples where people were being contacted by multiple different departments for the same shift. So this is just about trying to make sure that whatever the arrangements are, they're as efficient as possible and avoid unnecessary contact. But it's likely that health services have already undertaken this review, but just probably making sure that it extended to all the services and wasn't restricted to the general area, which I doubt it would be. Also, there's just the insertion of specific exceptions to the common right to disconnect clause for Section 2 employees. And that's really about enabling that contact to occur for additional shifts, etc. But those provisions are exactly the same as the general nurses. The rest and meal breaks clause, just inclusion of escalation process. So so each employee will describe in writing the steps to be taken where the employee does not take a scheduled meal break to ensure that that's taken, and the cause of it if there's a reason why they couldn't take it, so that we can address that in the future. And it's just about trying to create a loop so that people are not saying that they are unable to take the meal break every day for a long period of time. Portfolio work in paid time is a new clause, but not a new clause to the field. It's in the General Nurses Agreement. Just really says that where work's required to occur in relation to a portfolio or some sort of administrative responsibility, that will occur in paid time. Public holidays, a little bit of cleaning up just to commemorate the King's birthday, or changes there, a couple of other new public holidays. There is an amendment to the night shift. So amending the night duty public holiday payments to those hours worked on the public holiday to align that with industry standards. So the current or the previous entitlement really looked at the shift leading into the public holiday, and that created degree of complexity. We're just going back to the industry standard now, which we're dealing with the hours on the public holiday. I've just got a note there just saying we were hoping to create a common public holiday clause because for me, that's the holy grail of mental health, industrial, health sector industrial relations is getting to a common public holiday clause across the sector. But we'll probably have to do a little bit more work on that in preparation for the next round, because there's some complexities around how those entitlements are described against the groups that just made me a little bit cautious. Professional development and associated entitlements. So the substantive, well, it's not really substantive, it's more a clarification, is that deduction from professional development leave is prohibited unless an application is made. So the employee determines whether they apply for professional development leave. And we've just tried to simplify the clause by removing study leave and examination leave from the professional development leave to put that the separate clauses, and that hopefully makes it a little bit easier to read. So the study leave has a clarification that study leave can only be used for research and or studies in relation to a postgraduate course at a tertiary education institution which is relevant to a mental health nursing role. And we've also included some additional provisions that were sort of scattered through the agreement that dealt with study leave type programs. So the transitional program for PENs, for instance, the advanced diploma in mental health nursing for PENs. So we've included them in the study leave clause. But this approach is very much mirrors sort of the general nurses approach, where they've got separate sections. Examination leave is the other one that's been separated out. Now, clinical supervision is that clause 100. So this was one of the clauses that got a lot of attention. So clinical supervision arrangements to be guided by the Clinical Supervision for Mental Health Nurses, a framework for Victoria. There was a claim to make it in accordance with that, but we've just put it in guided because there are challenges to implementing it fully. Clinical supervision may be delivered either one-on-one or in group or on a group basis. Supervisors must have undertaken clinical supervision training acceptable to the employer. Clinical supervision will not be provided by the employee's line manager supervisor, and clinical supervision will occur on rostered time at a time mutually agreed. That's just to make sure that employers have oversight of when people are doing things. So where an employer and employee agree for the employee to become a clinical supervisor, so this is where someone wants to undertake that role. It's dependent upon agreement, so they can't do it unless the employer and employee agree that they will do it. The employee will be provided access to appropriate clinical supervision training before they start delivering clinical supervision, and that will be that particular training will be agreed between the employee and the employer, and it will occur on paid time. And finally, that employers will maintain and make available to an employee the record of trained supervisor who, subject to the availability, are able to provide clinical supervision to employees. So people will see by that clause it's greatly expanded, but they're the major points. In terms of 101 staffing clause, so there is placement of operational limitations on the director of nursing roles. So they won't have an operational role within the organisation in the traditional sense, and how that sort of needs to be interpreted is in relation to their the definition of role of task attributable to the director of nursing within the classification descriptors. There will need to be some additional EFT for members to be able to achieve that. and they will be allocated from mid sort of 2026 to the end of 2027 to enable people to do that. I'll just get my memory about where that schedule is, but we'll make that available to people so they know what schedule they'll be on. There is also a requirement for the senior psychiatric nurse to report to the director of nursing, and for a number of the educational roles to also report to the senior psychiatric nurse as well. In terms of community teams, there's a requirement that staffing establishments that include an RPN3 also have an RPN4 in its staffing establishment. So you can't have a community team just of RPN3s. There need to be RPN4s within that staffing establishment as well. There's standardised parental infant unit nursing staffing across all 3 shifts across the state, and there's a EFT that's been allocated for that. That will occur progressively across the agreement, and those dates are in Schedule 11. In addition to that, there's also an extension of the graduate support role trial that occurred and was highly successful. So that has been rolled out across the state, and 32 additional EFT than the EFT that's initially allocated and has been refunded across the state as well. So that's a positive, and those allocations occur on an annual basis in Schedule 11 as well. So they will be available for people. And just some amendments at 101.13 just to ensure permanent employees are prioritised over casual employees. I think they were existing entitlement, but they've just been beefed up to incorporate bank employees and pool employees potentially. Now, the other big change for the agreement is the insertion of minimum bed-based staffing profiles, and they're contained within Schedule 10. So people will recall that the heads of agreement from the previous agreement included work to be done about this, and it was done over the life of the agreement. But of course, by the time we got to finalise the agreement, all things had changed. So we had to work through it again, and Tanda's done an enormous amount of work on that. But they're now included in Schedule 10. The challenge with that is that as part of the agreement, they're enforceable as part of the agreement. So what we've needed to do is to put in the protections that are really to reflect the protections that apply with the Safe Patient Care Act, because it's really doing the same thing, creating a minimum staffing arrangement, even though it's a profile, not a ratio. So you can see there the exceptions to the obligation to do that. So where additional nursing staff are not available, where nursing staff are redeployed to another area with a greater clinical need. So you may only be able to get one EFT of additional people, but you've got an area that they're not suited to. So how can you use them? You can use them maybe by redeploying someone else. So that is a circumstance that's allowable, in assuming that you've tried to replace both people in both areas. You just can't try one; you have to try both. Beds are closed by the employer and then therefore unavailable to be occupied, and there's a process to go to do that. The employee commences no later than 2 hours after the commencement of the shift. So, for instance, they're doing that to ensure that they've had that 10-hour break after. To ensure they've had a 10-hour break after a shift that includes overtime, then that's enabled up to 2 hours. And finally, other reasons where the circumstances are beyond the control of the employer. I think I just saw Blair, you had a question?
Yeah, thanks, Tim. Just wanted to, I had a look at Schedule 10 and just looking at the staffing numbers recorded against the health services, and I think there are some discrepancies around what services might be staffing at versus what is the minimum. So where we may have already elected to staff over and above the minimum by putting on additional staff, that's now been noted in the EBA in the schedule as the minimum.
Yeah, so there will be a little bit of that, Blair, I think, because I think the commitment of government was immediately prior to the agreement, but there is a process, and I'm just wondering whether it's on the next slide. It's not, but there is a process that we can use, Blair. So if you contact me if you're concerned by that, both the unions and employers were both concerned that because of the amount of work that needed to occur prior to the agreement to capture what the staffing was immediately prior, that there's some room for error. So there is a process whereby that can be resolved post implementation of the agreement, but still have the effect of amending Schedule 10. So if you send me through where those areas are, then we can circle back to that and initiate that process.
Sounds good. Thanks, Tim.
No worries. So the maintenance of the ability to change the required minimum staffing arrangement where there's a change to the size of the unit. So that was an important step to maintain. So we've done that. We've also renamed implied dependency units to intensive care areas within that clause. And we've also consolidated all the existing staff replacement provisions to 102.A, which is staff replacement. So they're all existing provisions, and we've just put them all in one place because of the obligation now to maintain those bed-based staffing profiles. Staff replacement is going to become important. So we think that's going to facilitate that process. I should just say that part of that clause 102 is going to be making sure that employers maintain their obligations under the agreement to proactively do the things that they need to do. So things like that, advertising of vacancies. So to have access to those exceptions, you still have to be doing all the things that are required by the agreement to replace staff and do all those sort of things. So it is in the material that we provide, and it's in the agreement because the clauses are full. You can see that those exceptions are subject to compliance with other clauses. So it's worthwhile just people prioritising looking at them to make sure that they're doing the things necessary to access those exceptions, because they're going to be probably reasonably common. So, if you're unable to get staff, then that's probably the anticipated circumstance. Okay. Undergraduate employment model is there, and really it's just been those changes of the general nurses agreement just applied to the mental health. I know the general is probably a little bit more advanced than we are in terms of their exposure to RUSON, but many employers have used them sort of since COVID, so are gaining experience now, like 4 or 5 years worth of experience. So just opening it up to the discretion of the employer a little bit more. So things like being able to engage RUSON on a casual basis, just to try and smooth out that availability issue that we know that we've seen across the sector previously. The removal of restriction on the number of RUSON, new clause to extend RUSON and the PQEN period beyond registration when an employee commences their graduate year. So what this is we had a little challenge under the previous agreement, both the general and mental health, where someone registered, where a RUSON finished their course and was registered as an RN, then they ceased meeting the definition of RUSON, so therefore they couldn't act as a RUSON, even though they probably wanted to, and the employer probably wanted them to, and the graduate year may not be for another 2 to 6 months or whatever it is. So what this enables people to do is to extend their classification as a RUSON to a later date to overcome that period of time. Particularly important when we know that APRA are taking great strides in registering people as early as possible. So it's actually bringing that problem forward for us. So this accommodates that issue for us. The other change is just the consolidation of the 3-year RUSON pay structure into a single rate, and that's 81.5%. So what hopefully that will do is it'll make the RUSON role more attractive immediately for people encourage them to undertake those roles where they're established within health services. But those arrangements are the same as the general nurses. Commencing grades for nursing, there is an issue with the PN4 where they start as an RPN, so that's been sorted within the new agreement so that they're not going backwards and disincentivised. There's a whole range of changes to registered psychiatric nursing classifications. I've probably undersold them a little bit here in dot point, but it is worth having a look through. So the research nurse, there is a structure within the agreement between 2 and 5 or 2 and 6, I think it is, based on the general nurses research nurse classification descriptors. So if people do have dedicated research nurses, then they will use that to translate them across. The three-tier NUM structure, which is a clause in itself, so we'll talk about that in a second. An updated nurse practitioner definition. So we've adopted the APRA definition of nurse practitioner. So that is a change within the new mental health agreement. The updated educator classification descriptor. So what that does is it sort of combines the role description with the classification descriptors. It amalgamates the two into a single descriptor because just to try and reduce any inconsistencies between the two. There is an insertion of a new classification descriptor for Deputy Director of Nursing. So that is a new descriptor. I do believe that some health services, not many, but some do have a Deputy Director of Nursing. This provides a classification within the agreement to place them on. And finally, the Senior Psychiatric Nurse and the Director of Nursing descriptors have been significantly updated. So in particular, the Director of Nursing, as it relates to that non-operational role, people will really need to have a close look at that in terms of the assessment of the current Director of Nursing role responsibilities to align them with the changes to the agreement. Probably we'll do some implementation stuff on those because we'll probably need a bit more of an explanation. I mean, people will be able to work it out, but we'll do some more stuff to assist. So this is the change to the NUM nurse unit manager classification within the agreement. So as people can see, it is different. It's different to the general nurses and it's different to the current arrangements. It looks more complicated than it is, but I can explain it this way. So there is 3 levels of NUM, and it's really broken into 2 different sections. So it's broken into 6 beds or less, or more than 6 beds. So if you're 6 beds or less, then you start at level 1 for the first 4 years, and then you progress to level 2, and that is your ceiling. You don't go anything above level 2. If you're a NUM of greater than 6 beds, you start at level 2, and you progress to level 3 after 4 years of experience. So that's in a nutshell, how the structure works. In terms of Mark's just asking about the salary circular. So my mate Yvonne is just on leave at the moment. She's back next week. So we're definitely going to have it out by the end of January, but we're hoping to have it out next week along with the implementation guide. So that should be coming very shortly. In terms of the transitional arrangements, so the wages of those 3 levels are tied to the general agreement because we tried to maintain equity across those 2. So to do that, what we've had to do is preserve those employees that would transition to grade 5 level 1 as level 2 employees. So if I'm responsible for 6 beds or less at the time the agreement commences, and I've only had 2 years of experience, I won't be translated to level 1. I'll stay at level 2. Yeah. I think that's. Is there any questions about the num in particular, just while we're on it? Okay. That is one of the things we'll do a podcast on, just or some more implementation material. It's easy once you get it, but if you look at it in the first instance, it can be a bit confusing. That takes us to section 3, health professionals. So the health professionals also receive a once-off retention payment. So that's the AHP ones. It's limited to the AHP ones, which is the majority of the health professionals. So the once-off payment, it will be paid the same as the mental health officers. So split in over 2 payments. It's a lesser amount. It's 4,200, and it will be paid in $2,100 increments. But the same rules apply to proratering for part-time employees and payable to casual employees based on average hours over the last 12 months. The qualification allowance is increased for our health professional colleagues a little bit earlier than nurses, but in accordance with Schedule 2. So you'll see that there. The same with the shift work allowances. They'll also increase to encourage permanent night shift. Not that that's as big an issue for our health professional colleagues, but the same treatment has been extended to them. Also, change of ward allowance has been extended to health professionals as well. And it's probably going to be for a more limited scope for health professionals, but there will be some that will fall within the confines of being ward-based and all the other sort of criteria that apply. So it's the same entitlement unless an exception applies. So again, people need to be shift or the equivalent of the shift. So again, casual employee, bank employee, and pool employee are all excluded. An employee whose role is generally not ward-based or who does not ordinary work in a ward is also excluded. So we may find that is relevant to the health professionals, maybe more than the nursing fraternity, but that provision is there. Yeah, it's just based on the Section 2 entitlement. Crew days off, same provision as elsewhere. Keep seeing that. It's like, where's Bobby? The roster, and I'll tell you, Begs is recording meal intervals on the roster, has been inserted into the agreement. So whether people use a logbook or whatever it is, that's there. Process for employees to work on a public holiday is included, and 2 consecutive days off a week for employees working above 0.8 has also been included. And there is an opportunity for employees to request otherwise. Portfolio work in paid time equivalent to Section 2 entitlement has been included in Section 3. So people should be paid for work required to do. Cat on call has been amended to align with the nurses section in terms of relativities, etc. The calculations are a little bit different because the entitlement for the health professionals was a little bit different in that they took into account different days. So the base was a little bit different, but they've been aligned in terms of methodology to try and preserve relativity, but the precise entitlements and rates are in section 2. Same with the on-call. That also applies to health professionals. Public holidays, all the things that we've already talked about in terms of updating the clauses. There is a removal of Easter Saturday public holiday payments for employees who are not ordinarily required on a Saturday. That's been removed. And the clarification that employee rostered to work but are not required to work receive their day's ordinary pay has also been included. In terms of Section 3's professional development leave, there has been an inclusion specifically for lived and living experience workers. And that is really an additional 5 days beyond the professional leave entitlement to access or to undertake basic IPS training or equivalent as soon as practical after the commencement of their employment. And we know it's more limitations of spaces that are hurting us at the moment, but we do have the additional allocation within the agreement to help facilitate those staff attending that training. And there's a process to follow for that. Clinical supervision, so for non-lived and living experience workers, so clinical supervision to be guided by the Victorian Allied Health Clinical Supervision Framework. And again, that's guided just because we know that there were some barriers to fully implementing it, even though we probably all want to get there. Clinical supervision supervisors must have received clinical supervision training acceptable to the employer. There's a requirement for social workers and OTs to utilise discipline-specific clinical supervision where a suitable option is available. So that's the primary objective of everyone. But suitable option available, then there's the opportunity to do other things to make sure that supervision is still accessible. In terms of requirement for grade 4 or below to be of higher classification, we do need to be wary of that grade 4 because there is changes to the structure. So that means that grade 4 in the new agreement is actually the grade 3 in the previous agreement. And clinical supervision not to be provided by the employee's line manager or supervisor. Supervision will occur on roster time and mutually agreed time. Where an employer and employee agree for the employee to become a clinical supervisor, the employee will the same sort of provision as the nurses that we talked through, where it will occur on paid time, but there is the capacity for the employer to determine whether there's agreement and which course is taken. Employers will maintain and make available to employees a record of trained supervisors who, subject to their availability, are able to provide clinical supervision to employees. So that's for the health professionals. This is for the lived and living experience workers. It's a very similar approach in that they're guided by those particular frameworks. The difference between the primary difference is that lived and living experience worker supervision will be discipline specific, while the others weren't as definitive. The lived and living experience worker is. The requirement for the clinical supervisors to have received clinical supervision training acceptable to the employee is the same. The supervisor being of a higher classification or higher grade applies to lived and living experience workers up to grade 3 or below. Just the exclusion of the line manager, the use of supervision on roster time. There's an additional provision here for lived and living experience workers where the supervision is not available either internally or via an existing reciprocal supervision arrangement with other mental health and wellbeing services or other agreed services, the employer will be responsible for meeting the reasonable costs of supervision. So that's specific for lived and living experienced workers on the basis of trying to facilitate supervision for this group as far as reasonably practicable. And finally, that record of training that we've seen in the other provisions also included in the lived and living experienced worker provision. Sophie, you have a question?
Yes, hello. Just around the supervision training, probably more for allied health, but it might be relevant for Lou as well. Is there a time frame for when that supervision needed to have occurred? Because people might have done it 5 years ago. Is there anything that kind of defines that?
No, it's up to the health services, Sophie. So it's acceptable. It's training that's acceptable to the employer.
Right.
So
Okay.
so the employer gets to determine, is supervision training from 20 years ago satisfactory or not.
Right. Okay. All right. Thank you.
Wage review. So this is the hot topic at the moment on everyone's lips. There's a mechanism in the agreement for when the undervaluation decision is handed down by the Fair Work Commission, which has occurred now. Occurred on the 23rd of December, I think, from memory, or the 24th. I think it was the 23rd. Could have been the 24th, one or two. So there's a process for developing options for how that might be addressed. So at the moment, VHAA and probably the unions as well are just getting their heads around that decision and what it means for the rates within the agreement. So, but we've already reached out, the unions reached out as well, and keen to start that work as soon as possible. We are waiting for some additional material from the Commission, but we're trying to reverse engineer what they're doing at the moment to try and get ahead of it. But that work will be well underway sooner rather than later. But that's it's a great progress being made there. Support services. In charge allowance, I think had a reference to ward clerks or something similar that are no longer in Section 4, so we'll just remove that. So people may just need to check their systems to make sure that has been amended. They'll have the same treatment with shift work allowances as Section 2 and 3 employees. So that night shift will increase substantially in some areas, and it'll be tied to permanent employment as opposed to casual employment, just to try and incentivise that permanent night shift being undertaken. Accrued day off, poked its head up again. On-call, recall, again, that applies to Section 4 employees. I'm not sure how common it is, but where people are required to be on call, there are greater rates. I should just, I don't think I mentioned it previously, but I'll take the opportunity here is that part of those rates include the absorption of the telephone allowance that was previously payable. So the telephone allowance disappears from the agreement and is no longer paid under any circumstances, but the rate is incorporated into the new rates of the on-call allowance. So it's higher because of that. So people will need to be conscious of that moving forward, that telephone allowance does not continue. Our rosters, just a recording of meal breaks, the same as Section 2 accommodations have been made there in Section 3. There is no penalty for late roster release in these sections. It's just Section 2 that's in, and maybe Section 3. I'll need to check that, but not across the board. Public holidays, a few more changes for public holidays for support services. So we've got the updating public holidays again. We have the removal of Easter Saturday public holiday payment. for employees who do not ordinarily work required to work on a Saturday. Clarification: the employee rostered to work and not required to work also receive their day's ordinary pay. There's a reduction of the public holiday worked penalty for weekdays to 200%. That's away from 250%. And there's also insertion of public holiday rates for casual employees. The reason for those, the Easter Saturday and also the reduction 200% is that was an offset to the increase in the annual leave to 5 weeks. And it's the same offset that that occurred in the General Health and Allied Agreement, either the last round or the round before that. So now they're aligned with the General Health and Allied treatment. Shift work allowances, it's the same as the other group. So those increases will occur, and they're prioritised for the permanent employees. So the casual employees will get a lower night rate where they're required to do that work. ADOs, rosters, it's the same for Section 5 as the other sections. On-call, recall, it's the same. They've been increased substantially. So the telephone allowance has been incorporated into the base, and then there's an significant increase across the week dependent upon the day. Now, Donna?
Tim, I think I'm just paying attention to the date that's been set for the absorption of the telephone allowance. So given that that's a retrospective date where people potentially have been paid the telephone allowance, but then there'll be back payments for the new rates of the on-call allowance, that's going to require an extra step, isn't it, of potentially deducting from the allowance any telephone allowance that's been paid, and then presumably seeking permission to do so.
Yeah, so it'll be a deduction in the calculation of the payment. So, or you either look at it that way, or else you look at it that they've received the additional on-call early, or part of it.
But then how do you work out the portion that they haven't, given that it'll all be different? So I'm presuming that the salary circular that you released might just capture a note about that.
It did for the general.
Otherwise, effectively, if we're not recalling or deducting any telephone allowances that have been paid from May onwards, that'll essentially just be an overpayment.
Yeah, and we can note that in the implementation guide as well, just to make sure that it's in front of people's minds.
Yeah, thank you.
Okay. Public holidays for Section 5. So the same as the renaming or the inclusion of the additional public holidays. The removal of the Easter Saturday public holiday for employees who are not ordinarily required on a Saturday, and the reduction of the public holiday work penalty for weekdays to 200%. So they're again the same trade-offs for the additional annual leave. Clarification: of employee rostered to work but are not required to work receives their day's ordinary pay, which is the same as some of the other section. And the insertion of public holiday rates for casual employees. Just in terms of, so we're getting into the schedules. Nurses' salaries. So you can see there the increases. So the NUM, so they're backdated to the 20th of May 2025, which is the first thing you can see there. There's the introduction of the NUM structure. There's from the 1st of July, there's introduction of a second year of experience for nurse practitioners. And then there's subsequent increments, as you can see there. So again, those they include the gender under evaluation outcome for the nurses. It's a 3% each year plus the gender under evaluation outcome. And the allowances also increase. And it's just restating some of those night shift and high qualification dates. Mental health officers, their increases are a little bit more straightforward, but they've also received the lump sum payment. Health professionals structure changes. So probably in hindsight, Section 2 was not the place to place this, but this is where it was placed. But I'll just run through initially sort of from a high level what the changes are. And then there's individual translation arrangements within Schedule 2, 3.1 that people then describe how those things occur. So in the new structure, we have employed students at grade 1. So what that means is that the existing or the previous grade 1 employees are now grade 2 employees. So if you're a qualified health professional, you come in at grade 2 instead of grade 1. And that sort of bumps everyone else up in the structure. The grade 2 year 2 and the grade 2 year 7 are removed from the structure. So they're no longer there. And what that does is it makes it a 5-year grade 2 structure, which is the same as the general health professionals. There is a once-off automatic progression from grade 1 year 7 to grade 2 year 1 in the old structure. So what that is in the new structure, it's grade 2 year 7 to grade 3 year 1. So that occurs as a one-off time. That doesn't occur ongoing. That just occurs once off through this agreement, unless the employee elects not to. So employees have an opportunity to say, I don't want to assume the responsibilities of the new grade 3 level. I'm comfortable at grade 2 year 7. So there is a reserve rate within the agreement for those people who want to do that. The chief structure is removed from the agreement, and there's some translation arrangements that we'll go through in a second. There's 3 additional levels that have been inserted into the agreement, 6, 7, and 8. And so disciplined seniors will translate to either grade 5 or grade 6, depending on the translational arrangements. We'll go through them in a second. And grade 7 is deputy director, and grade 8 is the director, with no obligation for employees to appoint at either the grade 7, grade 6, grade 7, or grade 8 level. So that's broadly the changes in a nutshell. But how we get there is over the page. Probably could have made this a little bit bigger for myself. So in terms of the grade 1 year 7, so this is located at 3.18, and it really just says what I've just said, actually. So that all AHP1 employees employed at grade 1 year 7 at the commencement of the agreement will be paid the grade 2 increases from the 20th of May 2025. So they'll be backdated, and then they'll be translated to the grade 3 year 1 level unless they elect not to. And then if those people who elect not to transition, then they'll be grandfathered at the grade 1 year 7 rate moving forward. The discipline senior roles. Heather, you had a question?
I just had a question with that one. Does that mean if they elect to stay, they stay at the old grade 1 year 7? They don't actually go to become grade 2 year 5?
Yeah, so they continue to do the work of a grade 2 in the new structure, but they're preserved at the grade 1 year 7 rate, I think.
Okay.
is how the structure. So it's because all the grade 1s become grade 2s. So they're employed in accordance with the grade 2 descriptors, but they are the previous grade 1 descriptors.
but their classification remains at the old descriptor, even though they would be paid at the new grade 2. What would be then the new level? Like, that might be quite confusing.
I'll just check how we've worded it in the. So we've got a preserved classification that sits outside the classification structure. I'll just see what that. I think it's still grade 1, year 7. I'll just check. So, yeah, so it's preserved as a grade 2, year 7. So it incorporates the shift in nomenclature from grade 1 to grade 2 in the new structure.
Okay, thank you, Tim.
No worries. So the second translation is discipline seniors. So discipline seniors are employed in the equivalent classification within the new structure. So we've got discipline seniors incorporated in grade 5 and at grade 6 within the new structure. So depending on what current level they are, they may translate to they translate to the equivalent. So if they're currently a grade 4, then they go across to grade 5. If they're currently a grade 5, they go up to grade 6, just with the existing nomenclature changes. And vacated discipline senior roles will be employed at the same level as the previous incumbent. So what this is about is about keeping it cost neutral over the life of the agreement, because we didn't get any additional money to implement new provisions. So that's what 1 is about. 2 is about where someone is potentially below that, and the translation to grade 5 or grade 6 would increase their money. Then there's just a little provision to enable employers to review whether they are in fact disciplined seniors, or whether that disciplined senior role title has just been something that has developed over time, just to confirm that they are actually operating as a disciplined senior. So if they're not, there's an opportunity to reclassify them in accordance with the structure outside the disciplinary senior responsibilities. And there is a final position there, 3, that any new discipline senior roles would come in at a grade 6. So that probably the critical thing is just to do. We'll just need to do some work at the start of the agreement, just reviewing those people that are using discipline seniors to make sure that we pick up anyone that really isn't undertaking the role of a discipline senior currently. Now, Heather?
And just to clarify, Tim, so that clause 3 means that refers to a newly created position. Is that
Correct.
right?
Yes, that's right.
Okay, great. Thank you.
Okay. And then finally, Sophie.
The chief roles don't have that title in some of our services, I suppose. So that will be part of that translation piece of working out whether they go across. But I suspect there will be a cost to that for us.
Yeah, and look, if through the implementation you're finding that there's some nuance, and just out, and we'd be interested in talking to you about that.
Okay.
The other ones are for the chiefs, because we've got a chief structure in place at the moment that's really not suited. So people are sort of using it, trying to use it. So with that being removed, what the process would be is that those employees who are classified immediately prior to the commencement of the agreement as a chief will be reclassified in accordance with the classification descriptors contained in Schedule 5. And where where they translate to a rate that's not as high, they'll be salary maintained, but they'll do that transition into the structure properly that looks at managers, etc. And where there's a dispute about where they translate in, we'll use the dispute resolution procedures to be able to. Yeah, I thought that's so. To identify what that is. But it is one of those things where we're sort of moving away from a structure that wasn't working at all into the new structure. So there's going to be some teething issues, I imagine, but we'll work through that together. The translation processes for the health professionals, the salaries are there. So they're annual increases with an uplift initially. They're the allowance increases, including the night shifts and the high qualifications. The on-call happens immediately, so that's why the on-call's not immediately, it's not called out, and that goes across the different sections. Donna?
Yeah, thanks, Tim. Just going back in relation to the guidance that's been provided around that's going to be important for us to work out, and this is about grade 6, that someone really is doing the work as the discipline senior. What's the advice about how we measure that, given the agreement that's been voted on defines it as a grade 6 employee appointed in the clinical area of expertise may be described as a discipline senior? So that's we already are having obviously discussions about that. So we're just trying to turn our mind to what will be the transparent measure about what is a discipline senior.
Yeah, and I think it's about the equivalent classification. So don't click on it again. I think it's the equivalent classification, so that might need to be the term. So I'm picturing
the current agreement, unfortunately, doesn't have an equivalent for a discipline senior. It's a bit silent.
Yeah, so I think,
and I know I've raised this sort of, the fact of the local disputation increasing in this space previously, but respect this is where it landed and what we've got. So I'm just not quite sure what the measure of that's going to be.
Yeah, and look, that I recall you raising it previously, Donna. So I think our commitment was to focus on that as one of the key implementation things to get done sooner rather than later. So in my mind, I've got some things about what that might look like, but I'll develop that and share it with the reference group.
That'd be fantastic, and I'm hoping that what in your mind is similar to what the industrial bodies are going to be advising is the outcome as well.
They always agree with me, Donna.
Thanks,
Just
Jim.
for people that is not true. They don't. All right. So we've got the allowances for the lived experience, the support services allowances there. The other translation or things that people should be conscious of is the management and administrative officers classifications. So so what's happened here is people probably will be aware of is I think for the first 5 or 6 classifications within the structure, there's 5-year increments have been introduced. So, for instance, it's level 1 instead of just being level 1. It's level 1, year 1 through to year 5. So that gives people a significant increase over the life of the agreement. But how that operates in terms of its implementation is that everyone starts back at the first year. So what that means is that for all existing employees, they will be backdated to the 20th of May 2025 as a level 1, year 1, for instance. And then on the 20th of May 2026, they'll increment to year 2, and subsequently, they'll continue to go. As people have come on after the 20th of May 2025, their year increment will be on their normal anniversary year. So say I come in at the 30th of May 2025 as a grade 1, year 1, and my anniversary date will be the 30th of May 2026. So and it'll eventually everyone will transition to the new arrangement. So that's how that will occur. But as people know, that there's significant increases in that new classification structure for our colleagues covered by Section 5 of the agreement. That's them. There is a change in the CNS application process, or PCNS, PRN2, where successful applications are backdated to the first full pay period or after the application being made. And there's just a tighter process to try and get that done as quickly as we can. But we think having that pin in the backdated date sort of will resolve the disputes that inevitably occur in that space. And there's a few additional roles within the AHP1 structure. I think I mentioned these before. Maybe not all of them, actually. I think the health information manager wasn't there. So they're additions to the coverage, and also the transfer of a child psychotherapist and youth worker who's a degree qualified into AHP1 as well, because they're degree qualified. The lived-in living experience worker classification structure is another one that will need to be transitioned at the start of the agreement. So that's implementing a new structure with 8 levels and increased remuneration levels as well. So there's some significant increases for our staff in that group, which is good because we want to be able to attract and retain those guys. I'll come back to that comment in a second. And there's the establishment of new levels of roles at Deputy Director and Director, but no requirement to appoint. There have to be an individual translation process for people in this cohort. I think as a general rule of thumb, people will move up 1 level generally, and some will move up 2, and those that move up 2 will generally be the care and consumer consultant predominantly. But there may be some others in education and or management. So they'll have to be done at the individual level, but that probably is the rule of thumb to use. That help? Well, Helen, you're doing my trick on mute.
Amazing work you've done. Absolutely amazing. When it says the establishment of a deputy director and director role without requirement to appoint, what does that mean?
Well, I can see the tension there. So, what it means is that established a position within the structure for deputy director and director, but employers don't have to appoint to those roles.
Okay, thank you.
The other change is the inclusion of an allied health assistant structure within the support services. I think that's on the wrong slide. There's an allied health assistant structure based on the general allied health assistant structure within the agreement. That's just clarifying what I said before about, so there's 10 grades for the 5th Section 5, the management and administrative officers. The first 7 have 5 years of experience, and 8 to 10 is unchanged. Let's click the single. Schedule 10, just a few comments there on Section 10. So it reflects current arrangements, incorporates increases to the parent and infant units, and there is that process for managing disputes regarding applicable staffing profiles in place immediately prior to the commencement of the agreements, just ignoring of not being spelled correctly. And additional staffing reflecting current arrangements as well. But just in terms of next steps, so we've applied for approval of the agreement on the 5th of January. We will circulate the salary circular and implementation guide in January, but we're hoping to do that next week. The gender under evaluation process has commenced, and we'll be talking to people more about that over the next few weeks. If people obviously, there's going to be some back payments for the wages and allowance. We will flag that in the implementation guide just so people know which ones are which, and we consult with the unions over that. So that should be an agreed document. Scheduling of the weeks and then prioritising the various bits and pieces that will need to be implemented. So those ones there are the ones that we know that have got sort of a timeline on them, either from the commencement of the agreement or soon after. They'll be the priorities. But I think the best thing to do is to highlight that in our implementation material, so it puts it right under people's noses. I think that is the presentation. So that I don't know what the record is for doing 203 slides, but I feel like we might have given the record holder a bit of a nudge. But any questions that people have got about any of that or anything else that comes to mind? I think I did see someone's hand. Thank you, Donna. Did I see someone's hand go up? I can't see it. I saw someone's hand flash up, but then it's. Let me see. I agree, Jacinta. All right. Just checking. There was no. I didn't see anyone. No worries. So, all right. Well, if no one's got any questions, thank you for listening to my voice for an unnecessarily long time. Thanks, Roz, and thanks, Jacinta. Appreciate everyone coming today and listening, and particularly for those who have been on the reference group for the journey. Thank you very much. You deserve some sort of medal, but we'll see everyone in the reference group soon. Thanks, everyone.